Landlord gave me an N4, what happens next? Androbidistan, Osaksh. Ontario Tenant Rights Explained Intro. Hello everyone, welcome back to Pathway Legal Consulting. Today's topic is one of the most common questions asked by tenants in Ontario. My landlord gave me an N4 notice. What happens next? Many people panic when they receive an N4 and think they have to leave immediately. But that is not necessarily true. In this video, I'll explain what an N4 notice is, whether you have to move out, what the landlord can do next, what happens at the landlord and tenant board, and how you may still be able to avoid eviction. Let's get started. What is an N4 notice? An N4 is called Notice to End Your Tenancy. Early for non-payment of rent. It is the first step a landlord takes when rent has not been paid in full. Receiving an N4 does not mean you have already been evicted. It simply means the landlord is notifying you that rent is owing and giving you an opportunity to deal with the arrears. Do I have to move out immediately? No. This is one of the biggest misunderstandings in Ontario. You do not have to pack your bags and leave simply because you received an N4. For month-to-month tenants, the notice normally provides at least 14 days before the termination date. Until the landlord and tenant board issues an eviction order and the sheriff enforces it, you are still legally a tenant. Option number 1, pay the rent. If you can pay all of the arrears, plus any additional rent that has become due, the N4 notice becomes void. In simple terms, pay everything that is owed, and the eviction process stops. For example, suppose you missed May's rent and received an N4. By the time June arrives, June's rent is also due. To cancel the N4, you generally must pay both May and June rent. Option number 2. Move out. Some tenants decide to move out voluntarily. If you leave by the termination date stated on the notice, the tenancy ends. However, moving out does not automatically erase the money owed. The landlord may still pursue rent arrears. Option number 3. Do nothing. Many tenants choose to do nothing and wait. If the termination date passes and rent has not been paid, the landlord may file an L1 application with the landlord and tenant board. At this stage, the matter enters the legal process. What happens after the landlord files an L1? The landlord and tenant board will schedule a hearing. You should receive a notice of hearing, a copy of the landlord's L1 application. At the hearing, both sides have an opportunity to speak. The landlord will explain how much rent is owing, when payments were missed, why they are seeking eviction. You, as the tenant, can present your side as well. Can the board refuse an eviction? Yes. The board has the authority to delay or even refuse an eviction in certain situations. Factors that may be considered include temporary financial hardship, illness, loss of employment, disability, family circumstances, good payment history. Every case is different. Payment plans. Sometimes landlords and tenants agree to a payment arrangement. For example, current rent plus an additional $200 per month toward arrears. If both parties agree, this can sometimes prevent an eviction. Payment plans are very common and can benefit both sides. Can I still pay after the hearing? Yes. Even after the board issues an order, tenants may still have an opportunity to pay everything owed and stop the eviction before it is enforced. This is why many people say, an eviction for rent arrears is often about money, not punishment. Can my landlord change the locks? No, a landlord cannot legally lock you out without a landlord and tenant board order and enforcement by the sheriff. Self-help evictions are illegal in Ontario. Common myths. Myth number 1. I got an N4. I have to leave in 14 days. False. An N4 is a notice, not an eviction order. Myth number 2. My landlord can throw my belongings outside. False. Only the sheriff can physically enforce an eviction order. Myth number 3. If I make one payment, the case automatically disappears. Not always. Usually all arrears and any new rent owing must be paid to void the notice. For landlords. Landlords should understand that. The N4 is only the first step. Errors on the form can delay the process. Accurate calculations are important. Proper service of documents matters. Final thoughts. Receiving an N4 notice can be stressful, but remember, an N4 is not an eviction, it is the beginning of a legal process. Know your rights, communicate with your landlord, attend your hearing, and if possible, work toward a reasonable solution.